Ohio.
Gentleman's recognized for 4 minutes.
Thank you, Madam Speaker. I want to thank the gentlelady from Minnesota for her great work here in the Congress and for yielding time. I rise in opposition to this legislation. We all know that sexual harassment and assault are as wrong can be. Victims of sexual harassment or sexual assault must have their claims heard. They must never be silenced or intimidated into silence. But the outrage we rightly feel on behalf of these victims does not mean we should rush to pass a bill that could leave many of them worse off. In the Judiciary Committee, we heard from experts about why this bill's approach is misguided. For example, some of the bill's supporters repeatedly claim that arbitration is what keeps victims from publicizing their experiences or going to authorities and law enforcement. But arbitration is not automatically secret or otherwise confidential. Agreeing to resolve a case outside of court is different from agreeing to silence. Arbitration does not prevent anyone from speaking out, and anyone who has agreed to arbitrate may still go to authorities and law enforcement to report the wrongdoing, and well, they should. There's an important distinction between agreeing to arbitrate and agreeing to silence. This distinction matters because much of the push for this legislation comes from concerns about secrecy rather than from an honest assessment of whether arbitration advances justice. Yet despite the focus on secrecy, the text of this bill never actually addresses confidentiality or non-disclosure agreements. Another key talking point for supporters of this legislation is that it gives plaintiffs more choice over how to resolve disputes. But that's not how arbitration works. Giving one party the unilateral ability to cancel a two-way agreement to arbitrate will functionally take the option to arbitrate completely off the table. For one thing, contracts will be far less likely to include an option to arbitrate in the first place now. For another, we know that if parties can't agree in advance to arbitrate, then they are unlikely to agree to arbitrate after there's been a dispute. As a result, the plaintiff may never get to arbitration. More often than not, victims do not have deep pockets or the potential for large sum litigation settlements like those that are available to high-profile figures. This bill will cause these women to lose the potential benefits of arbitration. Lawsuits are normally long and costly, and companies often have enough money to vigorously defend these claims. These lawsuits are an ordeal for victims who, in a normal case, must undergo discovery, give depositions, may even need to give public testimony. The rules of litigation may make it much harder for victims to tell their stories in their own words and get the relief they deserve. Arbitration can be a welcomed alternative to the rigors and trauma of litigation. But Democrats want to pretend that this bill won't limit access to arbitration for victims of assault. In reality, the bill is more about empowering the trial bar than actual victims. As drafted, the text gives trial lawyers every incentive to craft complaints that allege sexual harassment or assault to get whole cases out of arbitration and into court. Ultimately, this bill will empower the plaintiff's bar in ways that some of its supporters may not intend, but that Democrats and trial lawyers certainly do. For years, Democrats have pursued plaintiffs' lawyers' wish to gut arbitration agreements for all kinds of different claims. If Democrats and the trial bar had their way, everyone, from consumer of financial services to civil rights plaintiffs to those with antitrust claims and others, would be forced into court even if they would rather agree to arbitrate at the outset. But don't be fooled. What is best for plaintiffs' lawyers is not always what's best for plaintiffs. Let's ensure whatever legislative vehicle we actually use actually makes things better. I'm very concerned about this legislation, that it will actually play out how it will actually play out for victims in practice and for the adverse consequences it could have. And for those reasons, I would urge that we oppose the bill, and with that, yield back, Madam Speaker.
Gentleman